Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want to talk with you about this very recent case decided on the last day of February 2022 from the 7th Circuit Court of Appeals. And this involves identity theft, and it's a lawsuit against LVNV Funding, an infamous debt buyer, and Resurgent Capital, which is a related company. These are debt collectors. And the lawsuit arises out of identity theft and involves the FDCPA, Fair Debt Collection Practices Act, and the FCRA, Fair Credit Reporting Act. And we will see how the court handles this. The court actually rules against the consumer who is the victim of identity theft. Now, there are parts of this opinion that I think the court just absolutely gets wrong. But we have to deal with this reality. This is the 7th Circuit Court of Appeals, and they have decided what certain things mean under, for example, the FDCPA. So whether we like it or don't like it, we have to deal with it. There are consequences to this. And so we want to look at this and really analyze and say, whether I agree or don't agree with what the court says, do they give us any hints about, well, what could we do differently in the next case to avoid this type of result? So it's a fairly lengthy opinion, but I think it will flow if you're interested in this type of thing. Now, if you're not, then this would be incredibly boring to you. But if you're interested in how do courts of appeals, like the 7th Circuit, how do they deal with these consumer type issues? So let's see what we've got here. So we've got the consumer claims identity thief, opened a credit card, and then debt collectors came after him. And so he calls, he writes letters, and finally he gets it removed from his credit report. And then he sues. And he says, hey, debt collectors, you violated the FDCPA, Fair Debt Collection Practices Act, and the FCRA, Fair Credit Reporting Act. We have no doubt this ordeal caused him a world of aggravation, but the district court, that's the trial court, federal court, correctly concluded that his claims cannot succeed, and so they affirm. They say, yes, Judge, you properly threw this case out. So let's go back to the facts here. So someone opened an American Airlines Citibank credit card under the name Kevin Woods. They made one purchase, a one-way flight from Dallas to LA. It ends up with fees and stuff, about $700. American sold the account to LVNV Funding, placed it for collection with Resurgent Capital. And so Resurgent sought to collect the debt from who else? Kevin Woods, the plaintiff. But he says, hey, it's not mine. Okay. And so he disputed this. And there was a letter that came back from Resurgent saying, hey, we looked into this. We verified this debt is your debt. And they say, here's an account summary report. And this shows that it belongs to a Kevin Woods in Tipton, Indiana. And so then he's calling and writing Resurgent, and Resurgent says, provide documentation details in writing to support your dispute. And then Resurgent started reporting the delinquent account to the credit bureaus. But they did say it was disputed. And so there are a couple more letters. And so the court points out there's a copy of the disputed account's final statement, and that's not the plaintiff's current address, but a different address in the same city. And he had not lived there since 2013. And the second letter said that Resurgent found insufficient evidence to support his fraud claims, but they say, here's some documents. So you can get us a filed police report, a notarized identity theft affidavit. You can get a letter from American Airlines, court documents. Maybe you can show the identity thief has been found guilty and charged with identity theft and found guilty. That would be helpful. And so then the court says he did not respond to either letter. Instead, he called American Airlines, and so American sends him two letters, and they say, hey, this is yours. And so then he goes to the local police. And the police officer wrote in his report that American Airlines had completed an investigation and determined that it was in fact his debt. Not a very helpful thing, by the way. And so then June 20, he disputes the debt with the CRAs, that would be the consumer reporting agencies like Equifax, Experian, TransUnion, and he gave them a copy of the police report, which contained that officer's commentary that said, hey, American Airlines found that this was your debt. So the CRAs then do an ACDV, automated credit dispute verification. So that's just the way they communicate with furnishers like Resurgent and LVNV. They do it through a process called eOscar. Think of that as just the communication line. And an ACDV is, hey, here's somebody saying something is wrong. You, the furnisher, investigate it. We, the credit bureaus, are supposed to investigate it also. And then we come up with a final decision. So Resurgent again matched his name and address to the account information and verified that it was his debt. Okay. Now, we know this was not his debt, but Resurgent said that it was. So then he files a lawsuit a couple months later. The next day, Resurgent sends him another letter saying, give us documents. And then a couple of weeks later, American wrote to say that, oh, wait, this is not your debt. Okay. And the court says, we don't know what led American Airlines to say that, but American Airlines did finally say this is not your debt. And so once Resurgent finds that out, they ask the bureaus, again, Equifax, Experian, TransUnion, to remove the account, and they did. So what are the claims? We can have the FDCPA and the FCRA. And so he says they violated the FDCPA by using false representations or deceptive means to collect or attempt to collect any debt. So this is under Section 1692E, and E deals with any type of misrepresentation or false conduct that would trick you or lie to you. And this is specifically subsection 10. And the court says, and I think this is absolutely correct. Now, they disagree with this, but they say in the consumer's view, the letters were literally false. Well, why were they literally false? Because they stated he owed a debt that was not actually his. Now, that is correct. Those letters were literally false. The Seventh Circuit has an odd way of viewing this, though, so we'll see that. The district court, again, that's a trial court where we start off, granted summary judgment for the defendants on two bases. Number one, they said, hey, Mr. Consumer, you did not show this is a consumer debt because you don't know what it was used for, whether it was business or personal. And this is correct, you have to show this is a consumer debt to get the protection of the FDCPA. And then the court said, but even if you could get past that hurdle, an unsophisticated consumer would not be deceived by the letters Resurgent sent. Sort of a weird thing to say, but we'll understand when we get a page or two into this why the court says that. Next, the consumer says, hey, Resurgent, you violated the FCRA, Fair Credit Reporting Act. Well, how'd you do that? By failing to conduct a reasonable investigation into my fraud claim. And so this is what's known as the furnisher liability. So we have two groups of people. We have the credit bureaus, Equifax, Experian, TransUnion, and then we have the furnisher. That's the one that provides or furnishes the information to the credit bureaus. We can only sue the furnishers under the FCRA if we notify the bureaus and then they notify the furnisher, and then there's an obligation under this section 1681 S2B. And so the district court said, hey, Resurgent did a fantastic job, closely examining the claims. Even before the ACDV, remember that's that automated consumer dispute verification, triggered its obligation to do so. The firm immediately noted the dispute, asked Woods to send in records that could help resolve. And then the court said one piece of information that he did provide the police report actually hurt his case. So remember, American Airlines said this is yours, and so the police officer put that down. Again, not helpful to the consumer here. The district court entered summary judgment for Resurgent, finding the reasonableness of its investigation beyond dispute. So remember this, under the Fair Credit Reporting Act, it's not enough that the furnisher, like Resurgent and LVNV, is wrong. Okay, it has to be unreasonable. So what we call a negligence standard. So that's what the court's looking at under the FCRA. Was it reasonable or unreasonable what Resurgent did? So now they're going to circle back to the FDCPA. Remember, there were two reasons why the court said, the district court said, you lose the FDCPA. One, you can't show it's a consumer debt. And number two, nobody could possibly be tricked by this. So the FDCPA's protections apply only to consumer debts. So that would be, let me just sort of highlight this here. That would be primarily for personal, family, or household purposes. And so you have to have some evidence. And so that's true even when you're a victim of identity theft. So let's just stop here and think about this for a second. If we're a victim of identity theft and some unknown person, maybe even known, but somebody other than us used the card, how can we prove what they did this for? Now, we face this. We had a case, and this is fairly common. Lawyers file a lawsuit under the FDCPA, and then they get close to trial, and they'll bring us in, my partner and I, Stan Herring and me, bring us in to try the case. Well, this was identity theft, and one of the arguments was, well, you can't specifically show what the items purchased were used for. And so there's no way that you can have an FDCPA claim. Okay. Now, we were able to overcome that, and ultimately the case was resolved. But we're going to see the Seventh Circuit kind of wrestle with this, actually have a good outcome on this. I think the rest of the opinion, not so much a good outcome. But, we want to follow their logic to understand what they're saying here. So they say, look, in this case called Burton, so this is Burton versus Cone Law Firm, we held the plaintiff had not met his burden on this point of proving that the debt was consumer. Burton alleged someone fraudulently opened a credit card. We explained the evidence of the types of purchases made on the credit card may be relevant to whether those were made primarily, doesn't have to be exclusively, but primarily for personal, family, or household purposes. But the transaction log did not tell a coherent story one way or the other. It's like gas stations, convenience stores, office supply, auto parts, pizza, local school district. They said many of these purchases could plausibly have been made for business purposes, even if they did not obviously signal such purpose. And so they say this is a toss-up, and so you, the consumer, lose. Now, pretty bitter pill to swallow when somebody does identity theft, and then the court says, well, because you can't prove what the thief used the gas for or the pizza or whatever, then you lose, okay? And so, but how does this work here? Remember, there was only one purchase. It was a one-way flight, I think from Dallas to LA. I say because there's no way to know for sure whether the one-way flight in this case, so the one that the appeal is about, was purchased for business or consumer, the district court concluded he had likewise failed to meet his burden. And the court says, but look, our case, Burton, and the FDCPA do not require absolute certainty. It only has to be more likely than not. So if you can picture the scales of justice, they just need to tilt just slightly in favor of the consumer, just slightly in favor of this being a consumer or a personal type debt. So a jury need only find it's more likely than not that the balance on the credit card was a consumer debt. They say here the facts and context point in Wood's favor. They say common sense tells us business travelers, because think about it, it's an airline flight, right? So it's either for personal reasons or business reasons. Business travelers do not often purchase one-way airline tickets. A reasonable jury could conclude the odds that the purchase was made for consumer purposes were better than a coin flip. So if it's 50-50, the consumer loses. It's got to be like 50.1%. See, it's got to be just slightly more likely that it was consumer than it was not. So Resurgent says the FDCPA required Woods to do more. They said you could have subpoenaed American Airlines and identify the person that took the flight. And the court says, but what then? Maybe you could track down. Maybe you could persuade him to sit for a deposition where he's asked questions under oath. Hope he doesn't invoke his Fifth Amendment right not to say whether his flight was for business or pleasure. And look at the court. No way. That's just crazy to say that. That's a wild goose chase. And they say, we reject that. So they disagree with the district court on that. They say, no. This is consumer debt. But remember, there were two reasons why the district court threw out the consumer. One, you can't prove this is consumer debt. Excuse me. The appellate court rejects that. But then they say, all right, well, let's look at the merits here of the claim. So Wood's contention relies on hindsight. Because American Airlines now says he does not owe the balance, Resurgent's letters indicating that he did owe that were literally false. And they say, but literal falsity is not standard under Section 1692E. I would say this. It actually is. Now, the Seventh Circuit doesn't believe it is, but if we just read the statute, it absolutely is, okay? But this is why sometimes when people say, well, give me the 100% answer. Is this right or wrong? And lawyers say, well, it depends. And people get frustrated with that. But this is part of the reason why. Well, how is a judge going to look at this? Is a judge going to add something to the statute? Or instead, will they just interpret the statute exactly the way it's written? So let's see what the Seventh Circuit says. Literal falsity is not the standard under Section 1692. We have instead explained that if a statement would not mislead the unsophisticated consumer, it does not violate the FDCPA, even if it is false in some technical sense. So this is what the court has decided. A statement isn't false unless it would confuse the unsophisticated consumer. Now, again, in my view, that is not what the FDCPA says. That is the Seventh Circuit adding a requirement to the law that's not on there. The law just says if you use any false or misleading representation, then you violated the law. But now they've added that, say, well, if you don't trick somebody, then it's not really false. Now, this makes it more similar to what we would call a common law fraud. Okay, so under state law, there's generally the elements under state law for fraud would be a false statement. Well, this was certainly a false statement. And then you have reasonable or justifiable reliance. And that's where most courts would say, well, if it was not reasonable for you to rely on this, then it's not really fraud. Okay. And so the Seventh Circuit has kind of added that into the FDCPA where I don't think that belongs there. But let's go on and see what they say. Put another way, a statement isn't false unless it would confuse the unsophisticated consumer. And the consumer here is saying it requires strict liability for any and all false statements. Again, that's really true, but we rejected this argument in this Wall case, and we do so again. They say the FDCPA does impose strict liability in the sense that a collector need not be deliberate, reckless, or even negligent to trigger liability. But the state of mind, let's highlight this, of the reasonable debtor is always relevant. Again, I think that's wrong, but that's what the Seventh Circuit says. Woods has not explained why the collector's letters seeking to collect the debt were false, as that term is defined in our cases, as distinct from false in a literal sense. So they're saying, well, see, we've changed the definition of what's false, and so you have to prove it's false as the Seventh Circuit defines falsity in the FDCPA. And so they say, well, look, let me actually highlight this here. So they say a reasonable person, contrary to the assertions in the letters, would know that you had never opened a Citibank account. And so you would know that the letters were sent in error, just as he did. And so to me, this is kind of ridiculous, this sort of circular logic. Like, Well, if you know that you're not guilty of it, then the fact that they say that you owe the debt means that you know that's wrong, so it can't be deceptive. So they can make all these wild statements, and as long as you know that they are incorrect, then you can't sue them. Well, that's not the purpose of the FDCPA. Maybe the purpose under common law fraud, but that's not the purpose of the FDCPA. The FDCPA is to prevent debt collectors from saying things that they know are false or should know are false. Or even if they don't know that they're false, if they don't have this defense of what's called bona fide error, then they're still guilty. But the Seventh Circuit says, no, we don't agree with that. So again, if you're in the Seventh Circuit or a circuit that's adopted this standard, you have to know this if you're bringing a lawsuit. So they say the fact that American Airlines later confirmed his intuition the debt was not his does not render the letters actionable. The statements in those letters were not the ones that would influence a consumer's decision to pay a debt. So again, they're saying you would not pay this debt because you knew it was false. Now again, I think that that is completely wrong, because there may be a time where you say, wow, I don't owe that debt. I know I don't owe that debt, but I don't want it to go on my credit report, so I'm going to pay it. Or I don't want them calling my work, or I don't want them calling my family. And so you pay something that you know you don't owe. Well, if we take the Seventh Circuit literally here, they would go, well, see, that's not false. And I just think that that's incorrect. But again, you have to live with that if you're operating under the standard. So now they turn to the FCRA, Fair Credit Reporting Act. The investigation must be reasonable. So pro forma, just sort of like we're just pretending to do an investigation, they say that's not going to do. And then they say the reasonableness of the investigation is a factual question normally reserved for trial, in other words, for the jury to decide, unless the defendant's procedures were reasonable beyond question. So what they're saying is normally this should not be handled on summary judgment. We should let the evidence be presented in court and a jury decide. They say, well, what counts as a reasonable investigation depends on the content of the ACDV. Remember, the ACDV is the communication from the bureau to the furnisher, in this case, Resurgent or LVNV. And so this is what the bureau says, hey, the consumer says that something is wrong, it's inaccurate, it's incomplete. And then based on how much information is provided there, that can influence what the reasonableness has to be of the investigation. So they say in this case called Westra, scant information regarding the nature of the dispute, a claim the account, quote, did not belong to the plaintiff. We held the furnisher's limited investigation. All I did was verify the name, address, date of birth to be reasonable beyond question, because the ACDV was so lacking. Now, if you did more than that to the bureaus, and the bureaus sort of narrow it down to something that really puts no obligation on the furnishers, then you sue the bureaus, okay? And for the last 4 or 5 years, almost always the bureaus will forward your actual letter to the furnisher. So whatever information you give the bureaus will be sent to the furnisher. But they say we left open the possibility that had the ACDV indicated the dispute concerned fraud or identity theft, a more thorough investigation may have been required. And then they cite also to the Ninth Circuit, which is out on the West Coast. Pertinent questions whether the furnisher's procedures were reasonable in light of what it learned about the nature of the dispute from the description in the credit bureau's notice of dispute. That would be the ACDV. So the consumer says, well, look, you have to do a more thorough investigation. I attached a police report, and so this was not enough. And the consumer points out correctly, of course his name would match. That's what identity theft is. So it's a good argument from the consumer. And the court says, well, if that's all the information, he might be right. But remember, the ACDV also had the police officer's commentary indicating American Airlines sent 2 letters saying this was you. So that really has come back to haunt the consumer here. Far from helping the consumer's case, the information seemed to indicate there was in fact no fraud, no identity theft. and Resurgent was well within its rights to rely on this representation to some degree. Given that the ACDV made it seem that the vendor, so the vendor here would be American Airlines, had already resolved the fraud claim against him, Resurgent's next move was also reasonable. They invited him to provide additional documentation to make his case. They gave him a blank identity theft affidavit, and he did nothing. Okay, even though he knew about the out-of-date home address, the bogus email address. And so let's just stop right there. Are we getting a picture here that if we know information that would be helpful, then generally we need to be sharing that? Okay, because the court, whether fairly or unfairly, and I haven't read the underlying documents, I'm just going with what the court's saying here. They're critical of this consumer, saying, you should have spoken up. You should have given more information. Should have given an identity theft affidavit. You should have mentioned this out-of-date home address, this bogus email address. See, they say information that could have done much to clear things up. So they say under these circumstances, we cannot say Resurgent's investigation was unreasonable. Well, let's put that in normal language. They're saying we decide that no reasonable jury could find that the investigation was anything but reasonable. In other words, if you're a reasonable juror, you must find the investigation by Resurgent was reasonable. Then they say, but a word to the wise. This opinion is no license for furnishers to offload their investigation obligations to consumers by spamming them with requests for additional information. Instead, like all questions of reasonableness, our conclusions depend on the totality of the circumstances in the case before us. So they're saying, look, you have to look at each individual case. And this is why it's so important to develop your facts and to know what your facts are, to have those be in the record before the judge so that the judge will see, okay, yeah, I might think that you should win or lose, but it could go either way, and so I'm going to let a jury decide this. So I am interested in your thoughts about this case. What do you think about it? Do you think it's right? Do you think it's wrong? Do you think that if we had this to do all over again, how should the consumer have handled this? What if you were a victim of identity theft and you're in the Seventh Circuit? How would you handle this? What would you do differently? And this is no criticism of this particular consumer. It's always easy after the fact to say, well, you should have done this, you should have done that. You know, the reason we call it Monday morning quarterbacking, right? But we also can take this and learn from it and say, okay, well, here's what I would do differently. And this is all part of the process because a lot of these rules come from cases like we're just reading. So you have to kind of put all these cases together to get the accurate picture of exactly what the law is that will govern you, even though it might be different if you're one state over. You know, there are differences between the 11th Circuit, where I practice, that's Alabama, Georgia, Florida, and, for example, the 5th Circuit, which is Mississippi, and I guess Louisiana and Texas. I don't think there's any other state. But the point is, you know, Alabama and Mississippi share a border, but there are differences. Even though we're talking about the same law, there's different views of that law. So you really have to know for your particular area, how did the judges look at this? And then lay out your disputes in a way that will satisfy your judges, make the arguments that will satisfy your judges, present the evidence that will satisfy your judges. So hope you enjoyed this. I'll do some more of these when I get a chance, and you guys have a great day. Okay, thanks for watching us. Have a good one. Bye-bye.